May I, as has appeared to become customary for the moderators, express, certainly on behalf of the organisation I represent, the International Institute of Humanitarian Law, our very sincere thanks to the US Naval War College and our delight to be associated with this particular conference, which has grown in size and stature over the last few years. And in particular, the Institute values greatly its relationship with the US Naval War College, which not only involves, or includes, I should say, the Institute's co-sponsorship of this event, but also the exchange of teaching staff, or the support provided, I should say, to the Institute by teaching staff from the US Naval War College. And that's largely been due to the incredible, tireless efforts of Professor Dennis Mansager. And Dennis, may I please join many others who've already articulated their tributes to you in your leadership of the International Law Department here at the Naval War College, and for your vision and enthusiasm in the area of the practical dissemination of international humanitarian law, which the Institute greatly values, and we hope will continue even in semi-retirement, and we look forward to having continuing our relationship with you over the years to come. And indeed, I think the excellent Blue Book series as a reference point for both scholars and practitioners has been made even more valuable a reference through your development of this conference as a complementary activity to that Blue Book series, and you've set foundations for that, which are so strong that I think even Schmitty can't cock it up when he takes over. We've heard over the last couple of days a lot about non-international armed conflict being at the diminishing point of ever-increasing diminishing elements of the law. And as a practitioner, I can well appreciate that non-international armed conflict is one of those areas of law which has little substantive black-letter law or rules that apply to it by comparison to other areas of international humanitarian law and international law more widely. But as many academics might like to gaze at the horizon and pontificate about how one crystallizes the law at that point, being someone who has to face the near and the now, the here and the now, I should say, in terms of how to advise commanders today and tomorrow on the application of non-international armed conflict, I think it's important to recall that although NIAC might be seen as having a degree of uncertainty or certainly flexibility in terms of the definition of its parameters, it is something that is applied on a day-to-day basis. And the presentations yesterday, I think, demonstrated how problematic and challenging that can be. So as one of the co-sponsors of the event, I'd like to take the opportunity to urge the scholars who will be providing articles to this particular Blue Book to recall the need for practitioners, or need by practitioners, to be able to make reference to suggestions and advice on to how to apply the law in a practical context when producing your works, so that the Blue Book series can continue as one of those great points of reference for both scholars and practitioners in applying the law. Which brings me then to the topic of today's panel, because I think in all of the areas of non-international armed conflict, the question of enforcement is perhaps that which brings to sharp focus the practical application, or none in some circumstances, of the relevant legal paradigm. And we have three very distinguished scholars who I'm very happy to also comment upon have been involved in the practice in this area over many years. And I won't introduce each of them individually, as has become the custom. You have their bios in your packs. But sufficient to say that the Institute's delighted that every single one of them on this panel is in fact an elected member of the Institute, and underscoring the Institute's focus on the practical aspects of dissemination of IHL. As is all cases in military activity, it wasn't planned. I regret to say, I wish it were, but it's certainly a wonderful happenstance, and we're very pleased to observe that. Very briefly then, the topic will be broken down into three areas. Firstly, Professor Cerone will cover the criminal aspects of enforcement of non-international armed conflict, largely in the international context. Professor Hampson, who will speak second, will talk about the civil enforcement aspects, primarily focusing on state responsibility at international level, but also commenting upon the little-known and often little-discussed aspect of civil enforcement as between victims and non-state actors. And Professor Wedgwood, perhaps performing a role that this audience is well accustomed to, will play what we refer to in football terms on the other side of the pond as a sweeper, or a clean-up batter, I think you would refer to it as here, and summarize and touch upon a number of the other questions in terms of enforcement under non-international armed conflict. So without any further ado, I will invite Professor Cerone to kick us off.
Thank you very much, and thank you to the organizers for inviting me to participate. I'm honored to join this venerable group. I thought I'd talk a little bit about the situation in Libya and the application of international law therein. And then I'll focus on the ICC referral to get into the question of application of international criminal law in the strict sense and some of the issues that arise with Libya being a non-state party. Let me first sketch out the timeline for the Libya crisis and provide some of the context. We're all familiar with the protests that erupted throughout the MENA region over the past several months, Tunisia, Egypt, where they were rising to a greater flashpoint, and of course the ensuing changes in the governments of both of those countries. In Libya, the protests started in earnest in February. At that time, let's think a little bit about, pull it closer. Let's think a little bit about the rules of international law that are applicable at that time. Can you guys hear me now? Higher. Sorry. Thanks, Ruth. So let's start with basic principles. Sovereign equality of states, the companion principle of non-intervention. Basically, you can't go mucking around in the internal affairs of other states or, in the language of the Charter, interfering in matters essentially within the domestic jurisdiction of other states. Basic principle of the system. Of course, there's been some erosion of the non-intervention principle, but still a bedrock principle of the international legal system, a basic principle of the United Nations, Article 2, Paragraph 7, we're all familiar with, and also the fact that it can be overridden by Chapter 7 measures, right? So Chapter 7 of the Charter can override the non-intervention principle. Of course, it doesn't obliterate it, but the principle can be derogated from to the extent the Council chooses to derogate from that principle using its enforcement power. Other applicable rules, of course, prohibition on the use of force, Article 2.4. The law of state responsibility for injury to aliens to the extent foreigners get caught up in the violence. We also have international human rights law applicable. And of course, some international criminal law. So in the pre-armed conflict phase, you do have the prohibition on genocide, the prohibition on crimes against humanity. War crimes, obviously, that body of law doesn't become applicable until IHL becomes applicable, until you have a situation of armed conflict. The protests in Libya become more violent. You have a situation of, well, the protests and obviously the responses to them, a situation of internal disturbances not yet rising to the level of armed conflict. Derogation becomes permissible in a time of public emergency that threatens the life of the nation. Of course, Libya is a party to a number of human rights treaties, including the International Covenant on Civil and Political Rights without any reservations. There's just, I think, a declaration about not recognizing Israel, but no substantive reservations to its expression of consent to be bound by the ICCPR. Also, the African Charter on Human and People's Rights. So Libya could avail itself of its ability to derogate to the extent necessary under the covenant. To my knowledge, it hasn't derogated. That doesn't mean that it can't. I think the Human Rights Committee has accepted retrospective derogation. But again, there's a fairly high bar for derogation, and the Libyan government would have to demonstrate the necessity for doing so and also establish a temporal limit. And the degree to which it can derogate is also just that which is required by the exigencies of the situation. Let's see. February 25th, the Human Rights Council convenes a special session. The Council adopts a resolution. The resolution calls upon Libya, it expresses concern about the situation and also calls upon Libya to start complying with its international human rights obligations. It also appoints an international commission of inquiry to investigate the situation there and to determine whether and to what extent violations of Libya's international obligations are being committed. The Human Rights Council also makes a recommendation to its parent body, the General Assembly, to suspend Libya from the Council. I should mention Libya was a member of the Human Rights Council at the relevant time. You had some interesting defections going on, as we're all aware, including the Libyan ambassador in Geneva, who spoke in favor of the resolution. So at the time, the Libyan ambassador's credentials had not yet been revoked by the Libyan government. We saw a similar phenomenon in New York, where again the Libyan ambassador defected. And so we had the following day, on February 26th, an emergency meeting of the Security Council where it adopts Resolution 1970 under Chapter 7, imposing a variety of sanctions, including a travel ban, an asset freeze, and significantly a unanimous referral to the International Criminal Court. This is the first time the Security Council has unanimously referred a situation to the ICC. As you may recall, the Darfur referral had 2 abstentions. What was it, US and China? Here, everybody was on board. As I understand it, China was a holdout for some time, but ultimately even China came on board with the ICC referral. A few days later, on March 1st, the General Assembly takes up the recommendation of the Human Rights Council and suspends Libya from the Council. By now, Libya is, the situation in Libya is looking more and more like armed conflict in terms of intensity, duration, organization of armed parties. So then we bring about the application of international humanitarian law, and that other part of international criminal law, the prohibition of war crimes, comes into play as well. What about the continuing application of international human rights law? We know when it comes to international armed conflict, there's still some controversy on the question of simultaneous application, but that controversy is focusing more and more on the extraterritorial dimension and less on the law of war, law of peace dichotomy that the US sometimes refers to. And certainly in situations of internal armed conflict, I think there's not much dispute about simultaneous application, because the US, the practice of the US has been to remind other states that are in situations of internal armed conflict to comply with their human rights obligations. But there we're of course excluding the extraterritorial issue, right? So I think that's where the US still has some sound arguments, and there is some legitimate controversy. Also for transnational, non-international armed conflict, again, the US disputes simultaneous application. But again, Libya, we're talking about internal armed conflict, at least at this stage, and so there's far more consensus on simultaneous application of the 2 bodies of law. March 3rd, the ICC opens an investigation. On March 12th, the Arab League calls upon the Security Council to impose a no-fly zone and also to create quote-unquote safe areas. March 17th, the Security Council, again acting under Chapter 7, adopts Resolution 1973, authorizing all necessary means, use of force, both to enforce a no-fly zone, also to protect civilians, and also to protect civilian-populated areas. It expands the sanctions regime. Significantly, this resolution is not unanimous. We have 5 abstentions, a significant number of abstentions, including 2 permanent members of the Council. So we see both Russia and China abstaining, and of course those are 2 countries that consistently take a very robust understanding of the non-intervention principle. We also see Brazil, Germany, and India joining as abstaining members of the Council. Then in February and throughout February and March, the African Commission on Human and People's Rights receives a large number of complaints about the situation in Libya. The Commission takes the situation to the African Court on Human and People's Rights, which on March 25th orders provisional measures against Libya. Basically, the provisional measures indicate that Libya should refrain from further violations of human rights and should report back to the court within 15 days. In, let's see, mid-May, the ICC Office of the Prosecutor requests arrest warrants for 3 people, including Gaddafi. During this time, we also see complaints from other members of the Council and also members of the African Union that the multinational forces, which have by now begun their use of force in Libya, are exceeding their mandate, that mandate to protect civilians in civilian populated areas, taking the position that the mandate does not include taking out Gaddafi. That essentially the mandate was not one of regime change, it was one of purely defending civilians, protecting civilians and protecting civilian populated areas. And as you may recall, that mandate also excluded the possibility of occupation. So this leaves us with a number of interesting questions. One, of course, is the scope of the mandate. Big question, what exactly does it mean? What's included in the use of force to protect civilians in civilian populated areas? Also, who counts as a civilian in this context? Which raises questions of DPH and the continuous combat function. To what extent do those influence this analysis of what constitutes a civilian or a civilian populated area? If indeed there is going beyond the scope of the mandate, well, of course, when we have a violation of the prohibition on the use of force, to what extent does that look like an act of aggression within the meaning of the crime of aggression adopted in Kampala? Of course, that's not operational at this point in time, and the court wouldn't have a jurisdiction for a number of reasons. But in any event, we have this possibility now of thinking in terms of this crime of aggression. And as a threshold question to the crime of aggression, we have the act of aggression, which we see as a component of that crime set forth in the Kampala definition. Recall that it includes forces based within a state with the consent of that state, which might be the most analogous category, and then exceeding the scope of that consent would constitute an act of aggression. Now, the scope of the ICC referral. So again, the situation has been referred to the International Criminal Court. Libya is not a state party. So we have a couple of potential challenges. One is the immunity challenge, right? Gaddafi as head of state. Well, in all likelihood, if he winds up before the court, he'll no longer be head of state at that point in time. But in any event, we have this rule of customary international law of absolute immunity of heads of state. The Rome Statute, of course, abrogates head of state immunity. Libya is not a party to the statute, so that abrogation would not on its face seem to apply to a Libyan head of state. At the same time, we have some precedent, right? The Darfur referral and the prosecution of the president of Sudan. We have the court saying that, well, this is the ICC, there's no immunity before the ICC. So we do have this precedent that immunity won't stand as a matter of customary international law. It's not clear whether that's the case. But of course, there's also the possibility of relying on the Chapter 7 Security Council referral as a way of saying that, you know, notwithstanding the state of customary international law, that immunity is still abrogated. Another possible issue is the Nolam crimin principle. And here we get to the issue of individual criminal responsibility in a non-international armed conflict, at least for stuff that happened before the conflict became international. Generally, the ICC statute applies only prospectively, so usually Nolam crimin is not an issue. But when you have a referral of the situation in a non-state party, then you have a potential Nolam crimin challenge, and you have to look to see to what extent the crimes being prosecuted were customary at the time they occurred, right? So in this situation, if you're talking about crimes against humanity, probably no problem. On the customary law front, we have Nuremberg, we have the General Assembly affirmation of the Nuremberg principles. By the time the crimes against humanity provisions were incorporated into the Rome Statute, they were pretty widely regarded as customary international law. And of course, the Rome Statute sets a slightly higher threshold for crimes against humanity. So that would even make it easier to survive a Nolam crimin challenge. The Rome Statute, as you may recall, requires that the widespread or systematic attack be supported by a policy, which is a higher threshold than that set by the ad hoc tribunals. War crimes, it's a little trickier. Of course, the first thing is whether or not there is individual criminal responsibility for violations of the law of non-international armed conflict as a matter of customary international law. Pre-1990, that was far from clear. We had then the famous Tadic decisions of the International Criminal Tribunal for the former Yugoslavia, where the tribunal held that serious violations of Common Article 3 were war crimes. As a matter of customary law, breaches gave rise to individual criminal responsibility. Did state practice support that at the time? Was there sufficient opinio juris? There's disagreement about this, but there's a strong argument to say that at the time, customary law did not, in fact, provide for individual criminal responsibility in non-international armed conflict. That's not to say there weren't prosecutions under domestic law, but that goes into the question of how do you establish, as a matter of customary law, that violation of the law of non-international armed conflict gives rise to individual criminal responsibility. And of course, there are very ongoing debates about how much is required to establish customary international law in general, and specifically in this instance. You may recall the U.S. letter to the ICRC, which set a very high threshold for the establishment of customary international law, basically criticizing the methodology of the ICRC report, saying that there was not a sufficient basis in state practice and opinio juris, and that there was over-reliance on implementing legislation alone. And that implementing legislation could, of course, flow from treaty obligations, therefore undercutting an opinio juris that it constitutes customary international law. Nonetheless, there's been a lot of support for the findings of the Yugoslav Tribunal. And then, of course, the following year, the Rwanda Tribunal was established. And there, the Security Council clearly envisioned that situation as an internal armed conflict. So you have very strong practice of the Security Council affirming that there is individual criminal responsibility for violations of the law of non-international armed conflict. And you have statements of delegates to the Security Council. At the time both statutes were adopted, affirming the existence of individual criminal responsibility for violations of the law of non-international armed conflict. So a challenge to the court that there was no such individual criminal responsibility for violations of IHL and NIAC is going to fail on the merits, and of course the judges would never disagree with the ICTY and the ICTR on that point. As to which crimes in non-international armed conflict were recognized in customary law at the time the conduct occurred, there's some scope for debate. There have even been some recent additions, right? The hollow bullets prohibition that was just adopted in Kampala. So, of course, there is some debate over the scope of customary crimes codified in the Rome Statute, and if those war crimes are prosecuted, then perhaps we'll see some sort of Nolam crimin challenge. Another issue that arises with the referral is the jurisdictional exclusion. Just like we saw with the Darfur referral, there's an exclusion for those sent by non-states parties to the Rome Statute, and it purports to give exclusive jurisdiction to the sending states. A question that then arises is whether that exclusivity of jurisdiction is purely vis-a-vis the ICC, i.e. would it still be open for other states to prosecute? There's some debate over that point, and some delegates who spoke upon the adoption of that resolution took the position that this exclusivity was only vis-a-vis the ICC. It was not exclusive vis-a-vis the world. I think I'll leave my points there, and we can come back to any of this during the Q&A.
Well, thank you, Professor Cerone. The next batter on the list is Professor Hampson.
Thanks very much, Darren. I would like to thank Dennis and the Naval War College staff for the pleasure and honour of enabling me to be here. In the past 15 years, there's been a focus on criminal responsibility, partly because of the creation of ad hoc and now a permanent criminal tribunal. And I think not enough attention has been paid to the potential civil responsibility for violations of the rules applicable in non-international armed conflicts. So I'm going to be looking at civil responsibility. My main focus will be on civil claims before international judicial and quasi-judicial bodies, but I'm going to start with a brief reference to the possibilities of using domestic law. I'm dealing with legal obligations and not policy concerns. Obviously, insofar as I'm dealing with responsibility based on treaties, responsibility depends on ratification. In the case of civil claims, we need to remember some of the advantages that they present as compared to criminal proceedings. The first is, if you're bringing proceedings against a state or a group, the advantage is you don't need to identify the perpetrator of the violation on account of the responsibility of the state or group for the behavior of individuals attached to it. And Darren asked us to be practical. In practical terms, not needing to identify a perpetrator is hugely important. A second advantage of civil proceedings is that one would expect that there would be a different standard of proof from criminal proceedings. A third one, at least as far as the victims are concerned, is that civil proceedings would appear to give them more sense of control over the proceedings. They are the instigators of it, they shape it, and they determine what issues are raised. And as we'll see in a moment, I think that was an important element, for example, in the civil claim brought by the families of those killed in the Omar bombing in Northern Ireland. Of course, there is an issue of compensation. One needs to remember that whilst in some cases compensation is actually what the claim is about, in others, as far as the victims are concerned, there is also a symbolic value in people being held responsible, even if they don't actually get any economic benefit at the end of the day. When one's looking at claims in domestic law, one needs to distinguish claims brought before the domestic courts of the state alleged to have violated the rules and those brought before the domestic courts of third states. So dealing first with claims brought before the domestic courts of a potentially violating state. I have to put it like that rather than the territorial state, because a claim could be brought before the courts of state A, arising out of the behavior of state A, either in its territory or outside its territory if it's assisting another state in a NIAC. So starting with claims brought against the state itself rather than against the non-state actor. Whether it's possible to bring claims against the state will depend on the content of domestic law and especially any immunity for governmental acts from which the state may benefit. In some jurisdictions, it's possible to bring complaints against the state for acts within the territory, but there's something that would be called with different names, but which used to be called in England the Act of State Doctrine, which would restrict the ability of foreigners to bring claims against the government for acts outside the territory. I say it used to be because I'm not very certain of the status of the doctrine. I expected to see it invoked in the case of Beachy and Beachy, which concerned, this was against the Ministry of Defence, it concerned acts in Kosovo, and I've never been able to get an explanation as to why it wasn't invoked. So it might be, in theory, possible to bring complaints against the state, but I have grave doubts as to how effective that's likely to be in practice. You're going to need the cooperation of the police, prosecutors and judges, and in the very many countries where the rule of law is weak, either generally or specifically with regard to claims against the state, I would suggest that it's actually going to be difficult in practice to bring such claims. I have in mind, for example, the situation in Turkey in the 1990s, when there was a functioning legal system, but just you try and bring a claim against the state for a deliberate killing, for torture, or for setting fire to homes. It didn't work. What about claims in the domestic courts against a non-state actor? This might offer better chances both in theory and practice, because at least you haven't got the reservation of the state judicial machinery about holding its own armed forces to account. But here we need to distinguish a claim brought against an individual for violations of NIAC or against the group itself. In the case of the individual may not be worth suing. He won't have sufficient economic assets to make it worth suing. And if you want to bring a complaint against the group as such, there may be a difficulty if the group is actually unlawful in domestic law. I don't know generally how domestic courts deal with the issue of an attempt to bring... God. Yeah. I don't know, speaking generally, I don't know of the the domestic situation in domestic law if you're trying to bring a claim against an organisation that is in fact illegal. As far as bringing domestic claims before the courts of third states are concerned, the situation is significantly different, at least as far as the state is concerned. If you're trying to sue State A in the courts of State B, you're going to be met by the defence of sovereign immunity. And as is clear from the ICJ's decision in the arrest warrant case and a domestic decision followed by a European Court of Human Rights decision in the Al-Adzani case, the restrictions based on sovereign immunity, even when it prevents you from bringing claims based on violations of jus cogens, are still regarded as legitimate. Can you bring complaints against the non-state actor in the courts of a third state? In principle, there would seem to be no reason why you couldn't. There's an interesting example, in fact, within the United States, in the case of Jane Doe 1 and Jane Doe 2 against Radovan Karadzic. But again, there may be a problem if you want to bring the claim against an organisation, because the organisation may be internationally unlawful. And so if you've got a proscribed organisation internationally, can you bring a domestic claim before the courts of a third state? So given the problems with seeking a remedy at the domestic level, it's perhaps not surprising that attention needs to turn to the international level. At the international level, as far as individual non-state actors or the group itself is concerned, there are no international mechanisms, whether regional or at the global level, that enable you to call to account in civil proceedings a non-state actor. They could presumably be subject to arbitration, but that would be on an ad hoc and a consensual basis, and I know of no precedent. Yesterday, the issue was raised of whether non-state actors can violate human rights law and therefore be subject to international proceedings for that violation. I agree with every word that Knut Dorman said on the issue. There is absolutely no example anywhere of you being able to bring proceedings directly against a non-state actor. So at the international level, the only possibility of bringing a civil claim, i.e. nobody goes to jail, is by bringing a claim against the state. At this point, I think we need to recall the range of different non-international armed conflicts that can exist, distinguishing them for legal reasons rather than for military or practical reasons. Because we need to see who might have an interest in bringing a complaint against a state for the state's violation of NIAC rules. Remember, we are dealing with NIACs. You can have a territorial NIAC in the territory of a state against a non-state actor in its own territory. You could have a territorial non-international armed conflict against a non-state actor where some or all of the members of the non-state armed group were of a different nationality. You could have an extraterritorial NIAC against a non-state actor where the third state objects to the presence and/or the conduct of the intervening state. Or you could have an extraterritorial non-international armed conflict where you were in fact assisting the third state with its own non-international armed conflict, for example, Afghanistan. In all of these situations, Common Article 3 is relevant, and in 1.5, Additional Protocol 2 is potentially relevant. Clearly, if the conflict is within the territory of the state and it reaches the threshold required for Additional Protocol 2, then that might be applicable. But I want to raise a possibility, which is why I called it a half, where a group of states assist a third state in dealing with a NIAC in its own territory, and where that NIAC is of such a character as to be appropriately classified as Additional Protocol 2, is there not an argument that the assisting states, who aren't fighting in their own right, are bound by that classification, at least if they themselves have ratified AP2, even though it's not directly binding on them? But leaving that to one side, one can see that there are a range of situations, some of them where states may claim to be in some sense a victim, but others where they might not be a victim, but they might want to complain about the state's behavior. So when might the state bring proceedings because it is in some sense a victim? Well, first, if the fighting's in its territory. Second, possibly as a form of diplomatic protection, where the victims are its nationals. but the fighting was not in its territory. That bit's clear. We're used to hearing that human rights law and the law of armed conflict contain obligations erga omnes. So the question arises of whether a state that isn't a victim can enforce these obligations. I'm struck by the fact that there's a marked difference between simply saying that an obligation is owed erga omnes and saying that the judicial enforcement can apply erga omnes. I'm not confident that before the ICJ, the issue of standing could be overcome. However, there are examples where under international law it is possible for a non-victim to bring a complaint against another state for its violation of the law of armed conflict. The obvious example is Article 90 under AP1. That only applies in international armed conflicts, but it is a precedent for the potential enforcement by a non-victim. And of course, another possibility is bringing proceedings against another state before a human rights body. I'll come back to that in a moment, but as we get into the area of human rights, I think it's worth recalling that there are various tools in human rights law that I won't be dealing with, I think Ruth probably will be, that are also relevant in relation to state responsibility. There's the special procedures that bind, insofar as they bind anybody, but all states are obliged to cooperate with the special procedures because they owe their authority ultimately to the UN Charter. There's the treaty bodies who receive state reports and produce concluding observations, and there's also the strange process of universal periodic review. I won't deal further with those, but I would point out that particularly the special procedures have routinely raised issues about the specific human rights issue they deal with, where the problem arose during the course of an armed conflict. So going back to the question of interstate claims, if you look at the number of claims arising out of conduct in armed conflict before the ICJ, there have been some, not all that many, but some, arising out of international armed conflicts. There was the start of a case between India and Pakistan over POWs. There was the Nicaragua case. There's the Democratic Republic of Congo against various states. And there is the recent Georgia-Russia case, just to give examples. But once you start looking at cases brought before the ICJ involving non-international armed conflicts, you can't find them. Now, you're going to say, well, that's not surprising because they're non-international. But there is a place where you can find interstate complaints brought on account of conduct in armed conflict. And that's before human rights bodies. So it's not that states who are not victims, it's not that they're not willing to bring the cases, it's just they're bringing them in a slightly odd forum. It makes it particularly odd when states then turn around and say they don't like the idea of of individuals using human rights machinery to enforce the law of armed conflicts, when so many of them have done exactly that. For example, there was a case brought by Greece against the United Kingdom in relation to Cyprus in the early days of the European Commission on Human Rights. Then there was the big Ireland-UK case. Then there was a group of European states who brought cases first against Greece and then one against Turkey. There was a case brought by Denmark against Turkey, which is a weird interstate case because it was actually based on an individual complaint. And there's the huge one currently before the European Court of Human Rights, Georgia-Russia #2. It's not just in Europe this happens, that Ecuador and Colombia are slugging it out before the ICJ and also before the Inter-American Commission on Human Rights. So I'm left with the question, why are states willing to bring these proceedings before human rights bodies? Why do they want to secure some judicial recognition of what's occurred? This has to be obviously speculation. I think the first element is it's easiest to establish jurisdiction. A second one is it's possible that it's seen as somehow slightly less political than bringing it before the ICJ, because it's seen as upholding universal values since it's human rights rather than merely international law. And also the fact that under human rights law, there is available a mechanism that enables non-victims to bring proceedings. In the examples I gave, it's striking that in all but 2.5 of the cases, the states bringing the complaint may have had a well-founded complaint, but it also served a domestic political interest, for example, Ireland and the United Kingdom. The 2.5 exceptions, the obvious ones are the proceedings against Greece and Turkey, which was simply brought because they thought that the conduct that was being engaged in Greece and Turkey shocked the conscience of Europe. The half case is Denmark and Turkey, and as I mentioned, it's because it was actually based on an individual act of torture. So it's striking that those cases have been brought, but it's equally striking that there was no interstate case against Turkey for the situation in southeast Turkey in the 1990s, or with regard to Russia in Chechnya. And I think that's because the states feel they're let off the hook where there's a right of individual petition. So at this point, one can look at how this area is being used and the argument as to whether it should be used at all. Only Israel and the United States argue that the applicability of the law of armed conflict has the effect of turning off human rights law. The US position is undermined by its failure to veto Security Council resolutions which call on parties to non-international armed conflicts outside national territory to respect both human rights and the law of armed conflict. In this area, I'd like to quote Wolf last year, who said it's too late to argue this proposition that the applicability of the law of armed conflicts turns off human rights law. That train has left the station. The most important aspect of suits before human rights bodies in terms of the legal consequences for states is the exercise of the right of individual petition. It results in an opinion from the Human Rights Committee and a binding legal judgment from the regional human rights courts. So the question then arises of how these human rights bodies take account of the applicability of the law of armed conflict, when they should take account of it, and how they should do so. Now, there's no problem with anything prohibited under Geneva law, for example, rules on the protection of victims, whether it's Common Article 3 or Additional Protocol 2, because it will be prohibited under peacetime law and order rules as well. There's no problem with Hague law prohibitions, for example, things you can't target, things or persons you can't target, and weapons you can't use, because they will be prohibited under both regimes, subject to the important caveat that emerged during the presentation by Bill Boothby with regard to expanding bullets and tear gas. There's case law on that, Guleç and Turkey. Where there's most likely to be a clash is where something is permitted under Hague law, but not under human rights law. For example, when you can open fire. That's the obvious issue. It's the one everybody always identifies. But there are going to be two other situations where there are going to be problems. First, where there's no conflict between human rights law and the law of armed conflict, but where human rights law is more specific or more demanding. Everybody straight away thinks of detention. Again, that's the usual one. But in addition, there's another thing that I think needs to be remembered, and that's where whatever has occurred in the context of an armed conflict, whether or not there is a specific law of armed conflict rule. Let me give a couple of examples. Imagine a situation in which armed forces are confronted by a demonstration in a place where there's a non-international armed conflict occurring, or where they're confronted by hostile broadcasts and publications. So we're dealing with freedom of assembly and freedom of expression in human rights terms. Now, there's nothing in the law of armed conflict rules about demonstrations and about the role of the media. How can you apply a lex specialis if there isn't any lex? But does that just mean that you use human rights law? Now, I recognize that in this area, human rights law, for a start, has got limitation clauses. We're not dealing with absolute rights. And there's also the possibility of derogation. But even so, I think you need to take account of the fact that the context is one of armed conflict, even if you do it in the application of the limitation clause. So I don't think you can say if there's no armed conflict rule, then you should just apply human rights law in the usual way. I think that's the wrong approach. I think you should start by saying, is the law of armed conflict applicable? Never mind whether there's a relevant rule, is it applicable? Once it's applicable, it has to be taken into account by a human rights body. Now, it doesn't say so far how you take it into account, but it must be taken into account. And third, where there's a specific permissive law of armed conflict rule dealing with the issue, human rights law should be interpreted in the light of that rule. So there would only be a violation of the human rights requirement if there was a violation of the law of armed conflict requirement. Fourth, where there's no specific law of armed conflict rule, the human rights provision can be applied on condition that the existence of the armed conflict and the applicability of the law of armed conflict is taken into account when assessing the application of the limitation clause or the application of the derogation, if the state is derogating. And fifth, where there are general provisions in the law of armed conflicts, but the human rights law provisions are more specific, for example, in the case of detention, issues of lawful authority, grounds for detention, existence of review, periodicity of review, and so on. In those situations, the law of armed conflict should set the bottom line and the framework. I was very struck by a formula that Knut used yesterday, and I agree with him on this, in that he took vocabulary from GC4, in other words, the law of armed conflict, as the appropriate ground for detention in non-international armed conflicts. I would suggest if states indicated that that's what they were going to use as their framework, human rights bodies should take account of it. At the moment, there is a regrettable lack of engagement in this issue of the operationalization of the relationship between the law of armed conflict and human rights law by human rights bodies. States are just defending every case in a somewhat blind way. So they're not assisting the human rights bodies in sorting out an appropriate relationship. And whether states believe in this stuff or not, they're going to be affected because some of their coalition partners may be affected by judgments of human rights bodies, and it's going to affect the way in which other states perceive them. I've already said that the US has missed one train. They're in the process of missing another one. I hope that they will drive sufficiently fast to catch the train at the first available stop, but unfortunately I see no signs of that happening.
Thank you very much, Professor Hampson. And to end the formal presentations for this panel, call Professor Wedgwood.
Thank you very much, Mr. Chairman and my colleagues. And also, just since it's my only occasion for doing so, I do have to say, number one, thank you to Dennis Manzinger from long ago for putting up with all my bad habits as a Stockton professor and giving me the chance to affiliate with the uniform folks, which I had really never done before as a Yaley. It was a life-changing event for me, so I really am very grateful. My kid, who you bet happens to have been in utero here too, so he's one of the few Stockton babies. I didn't tell you that at the time. and thanks, of course, to Yoram Dinstein, who's the proud piece of the figurehead of so many of these conferences, who's been a great friend for many years. And then the pleasure just of having one's students grow up. Little Bill Litzau became somebody, and Michael Schmidt's going to take over. So that's a really very heartwarming kind of decadennial thing to see. And then I'm here, before I begin my formal presentation, also to pitch a product, if you'll forgive me, Mr. Chairman, we have time, which is the International Law Association, which I think in the U.S. has been less well known than the American Society of International Law. But it happens that some of its real doyens are here in the audience. George Walker chairs the Law of the Sea Committee for the American branch of the International Law Association, has just finished a new book on definitions in the law of the sea. And James Kraska chairs the Law of Armed Conflict Committee in the American branch of the ILA. And John Noyes is here, who's the outgoing president of the American branch. And we are going to have our annual conferences every fall in New York, if you're here for something else, in UN circumstances, International Law Weekend. And we may have an accelerated biennial conference too, in either certainly 2016, maybe 2014. So I invite all of you who are feeling lonely and insufficiently affiliated and haven't used up your annual department budgets to think about joining the American branch or your own branch of the International Law Association. And my pitch for it, which I'll close with right now, is that, and then I'll sit down and pass the questions, is that in a sense it's the only truly international law association. It does what the American Law Institute does. It drafts operative texts instead of just putting on panels. So if you want to take part in the great weaving of the fabric of international law other than through kinetic actions, just through texts, I invite you to look seriously at the websites of the ILA headquarters and ILA American branch. With that said, what I'm supposed to talk about, I will comment a little bit on both of my dear colleagues' presentations and go on a little bit more to other modalities. And so first I'll talk about, if I may, in a sense what John was adverting to, the role of war crimes tribunals. And I'm not really deep enough into the weeds on Libya to comment in detail on that, but let me just give you my very piquant takeaway of where we've gotten in the last, gosh, it's been certainly 12 years of institutional development in war crimes tribunals. And it's not Nuremberg anymore, that's for damn sure. And I forgive my forward New Yorkese nature, but I think a number of takeaway lessons. One is we can't try cases efficiently. The war crimes tribunals are really, I'll say, challenged in trying cases. The first rule of a girl-boy prosecutor is do it simply. 2 weeks, put your proof in, and rest your case. And these long, discursive, historical toile de liaison that all the war crimes tribunals engage in means they don't finish their trials. They don't get convictions. It complicates the proof. It complicates the message for the listening public. So it was a great pity and shame that, that the Milosevic case never got finished. And I would hope that the takeaway lesson that the Mladic prosecutors will have is get the damn thing over with. 2 weeks of proof, put your best proof on. It never gets better when you elongate these things. So I do think that there's a lot of, and I'm sure court-martial lawyers know this too, you just choose your best 3 witnesses. But the confusion between trials and truth commissions and the portfolio dossier method of European fact-finding has meant that these tribunals have cost too much, they've taken too long, the judges die, the defendants die, and they don't have convictions that really seem to be a takeaway product. That, so just very youthful anecdote. There used to be a judge in the Southern District of New York who'd say, young lady or young man, you have 2 hours to try your case. And when you'd complain, they'd say, that's it. And you'd pick your best 2 or 3 witnesses, and you'd get it over with. And so that is a lesson that I do think that those of us who have been trial lawyers and also happen to like international law should teach more broadly to the UN community, where this is not a permanent source of employment. Secondly, I've been disturbed at the issue of the segregation of tribunals. I confess I wrote critically about this, but there was something really wrong when the International Criminal Court for the former Yugoslavia couldn't share its evidence with the International Court of Justice, so that they got disparate holdings on whether or not genocide occurred in Srebrenica, or different theories, shall we say. It's just, I realize the difficulties of getting proof from participating states, but you ought not to have the tribunals of the international community speaking at cross purposes and undercutting each other. And that's something I think also that the Yugoslav Tribunal, so many of whose leaders I admire and respect and value their friendship, but I think they got it wrong. Third, we really haven't solved the problem in the disproportionate, the asymmetry of the choice of cases. I mean, Cy Vance gave very good advice to the Yugoslav Tribunal early on that they better do something like the Washington Naval Conference on capital ships, 531, have lots of Serbs, some Croats, at least some Muslims. And it took them a long time to get around to that because of leaks and other problems. But ultimately they did. They tried some of the malefactors from each of the communities, and I think that served to give each of the communities a feeling of some stake and some perception of objectivity in the Yugoslav Tribunal. However, and here's one of my very personal, if idiosyncratic peeves, the Rwanda Tribunal, completely different story. Spent just about as much money, used to be supervised by Richard Goldstone and Louis Arbour, and has never tried a Tutsi, ever. Now, to be sure, the bulk of the crimes in Rwanda were undoubtedly committed by the Hutu in the great Interahamwe massacres, but there were Tutsi incidents as well that were considered serious, that were reported on by that stunningly good historian Alison Desforges from Buffalo, who tragically died in the plane crash, that were supposed to be within the mandate of the court. And nonetheless, the court never got to it. Why? Because they had to do the Hutu cases first, or Kagame would have withdrawn any cooperation. They had to work in country in Rwanda, and Kagame was still in power. But then when it was time to think about a termination strategy, they terminated with no Tutsi cases. And the U.S., I fear me, was here complicit in the, or sorry, it's a criminal word, was co-responsible in this development. We actually demanded that the Hague prosecutor give up her Rwanda jurisdiction, so that Carla Del Ponte was stripped of her jurisdiction during the Bush years in the State Department by a friend of mine. And then it was given to an African prosecutor who in turn chose to give it over to the locals. So the Tutsi should prosecute Tutsis, Kagame should prosecute Kagame. And that's not a very satisfactory kind of evolution. It hasn't gotten much attention because he's our big ally and we like him, and he's got a lot of minerals from Eastern Congo. And he's kind of our anaconda of Central Africa. But it's a fact, and one that I think has a strong lesson for the future, and frankly, for remedy in the past and in the present. Because we have been, in my opinion, very uncritical of Kagame because of the uniqueness, we suppose, of his claim of victimhood, when there are many, many Hutu and dissident Tutsi who have also been victimized by this asymmetry. And not least, and here's the most controversial, the shoot-down, which came within the 1994 temporal jurisdiction of the tribunal and was preliminarily investigated by Michael Horrigan, whose report has never been published. So Judge Brugière may not be alone in thinking that there's more to this than meets the eye as to who shot down. It's certainly something that, since it's within the formal jurisdiction of the tribunal, and the most important event, in a sense, should have been addressed. So I guess the bottom line here is, don't suppose because they're criminal tribunals or United Nations tribunals that they're immune from politics. And to get the law right in a larger sense, you have to get the politics done in an even-handed way and not play favorites, which I think is a lesson that any judge would take if they had control over it. But because of rapidly changing prosecutors, because of U.S. predilections, other countries' predilections, it rarely gets ventilated in a way that's actionable. And I think it's something that belongs to more than historians for remedy. On human rights bodies, yes, I'm here to warn you. Since I frolicked away the last 8 years on the Human Rights Committee in Geneva, we think we have jurisdiction over you. I might have talked to my colleagues about lex specialis. That might have got watered down to especially relevant standards. But we think we're extraterritorial. We think that because Article 4 provides for derogation in time of war, therefore, if you don't derogate, the whole thing applies, and even if you do derogate, the watered-down version applies. So yes, ICRC may not like this either because of their long tradition of developing the law of war, but there's a civil war going on in Geneva between the treaty bodies and the ICRC and national militaries. And in the real-life world of proliferating treaty bodies, you better get used to it and come loaded for bear with a uniformed guy on your delegation, because he will be asked questions about battlefield conflict in your country and abroad. And I will confess that even though I had jurisdictional doubts, I too felt I yielded to temptation, because when you rarely have a country before you, say Mother Russia and Georgia, and they're there and you're there, how could you not ask a question? So it's something that can easily be met. Just bring a person with you who's skilled in LOAC and can answer the factual questions. I think actually the proper substantive world would have human rights law informing law of armed conflict and vice versa. So to try to maintain an artificial arm's length is probably not going to work. On the UN Human Rights Council, it has been a big disappointment to many of us. Ken Roth was wrong in supposing that having individual seat voting would assure a political body. But I will say that universal periodic review has been good, in the sense that countries that never otherwise come to Geneva to report do now have to come every 40 years. They blow off the treaty bodies This is not a literal transcript, is it? but they will come for UPR. And it's political, it's diplomats, it's contrived, it's 3 hours long. The NGOs can't take a direct part. It's frustrating, but it's better than nothing for Guinea-Bissau, which otherwise never comes. So that's been a good development. The Human Rights Council in general is no improvement from the Commission. However, it's all Israel all the time, 24/7, 12 months a year, with a peculiarly hostile attitude. The rapporteurs vary I think, in their quality and dedication. And some of them are very good. Some of them have particularly self-styled political views. I think there are so many of them that they are not taken as seriously as they should be, but some do very important work. Brazil, which had become a very violent place, had very good reporting, for example, by the Special Rapporteur on torture and on extrajudicial executions, and that kind of cumulative reporting gradually has, I think, some effect on the state party. The newest development, which I am concerned about, is political bodies in the UN, or ad hoc political ventures in the UN, or I shouldn't use the word political, but ad hoc investigative ventures in the UN, which I think have had a mixed and will continue to have a mixed record. And here again, I have many friends, so I say all that I say with great respect for their integrity. But I'm going to talk about Goldstone and Sri Lanka. On the Goldstone report, as it turned out, some of these issues were the most delicate, difficult kinds of questions of how you do counter battery against somebody who's firing at you. It was a difficult venue in which to put the issue because the Human Rights Council has been all Israel all the time. For those of you who aren't American, go out and get the record by Tom Lehrer from the we date ourselves, the 1960s, right? The Bulgarians hate the Ukrainians hate the Latvians hate the Lithuanians, but everybody hates the Jews. It was funny when it was set to music. It's true at the UN. And therefore, it was guaranteed to be, I think, a difficult venue in which to maintain sobriety and objectivity. I've known Richard for a very long time, since he was a South African magistrate, but I think he let himself be rushed, to be naive about whether you could actually take testimony about Hamas in public settings in the West Bank. I think a lesson for all JAGs here is that to really do a thorough scrub of why something happened on the battlefield takes time. And actually Israel this time, with Marlene Maisel and Shavit and my old student Roy Scherndorf, did a very, very thorough battlefield scrub, if you like, as to what had gone wrong, where doctrine was right or wrong, where there was misapprehension of the facts. And some of the issues, some of the developments were exculpatory, that the Hamas had been fighting in the concrete factory, the chicken farms or chicken coops. The police had gone over to be combatants as well as local Hamas police. It was a very good exercise for the Israelis. But in the course of it, I think the rhetoric that accompanied the sound and light show at the Human Rights Council was seen as so derisive that it was very hard for the party being investigated to feel that they had a fair crack at an objective tribunal. And certainly I take the point that people who do these investigations should also hold themselves to a judicial standard of disengagement, disinterest, and objectivity. So I don't think Goldstone was a huge success myself as a trial lawyer. I wasn't completely surprised when Richard wrote his op-ed saying if he knew then what he knew, he knows now. Of course, he did know it then because he was given a copy of the Israeli report in July of '09. But the other lesson from that is that when you get caught up in these tidal waves of political feeling, it's very hard to resist when they tell you that you have to report by the September '09 session of the Human Rights Council, and you're late, mother, could I have an extension? People go with what they have. And that is a kind of hydraulic that no battlefield investigator should permit himself to be stampeded by. So I think that one has, we can do a Goldstone was supposed to be lessons learned. There should be lessons learned on how not to do it next time. On Sri Lanka, I worry too a little bit. I confess this is a mot propre because I just took my students there over the spring break. It's a very interesting country, hugely prosperous economy. It yielded over the years many, many very well-regarded diplomats, like Jayanta Dhanapala, who was the champion of the Non-Proliferation Treaty, and Rohan Pereira and Judge Weeramantre, really elegant British-style comparativists, because they had to know Muslim law, Kandy law, English law, Dutch law, Portuguese law, and Sinhalese law. So they all were really skilled scholars. And it was a terrible war, 27 years. One's not going to say that the government wasn't at times heavy-handed, perhaps, but the Tigers were a very formidable foe and very ruthless, and killed all the moderate Tamil leaders themselves, and killed the Tamil foreign minister who'd served for almost a decade in Sri Lanka, and were actually the original focus of the UN Convention on the Financing of Terrorism. That was not about Al-Qaeda. That was about the Tigers, because they were being sustained by a Canadian Tamil diaspora, such that every ceasefire turned into an occasion to renew the materiel and money for the war. So I don't know Rajapaksa. He's from the south. He's sort of a Santiago de Cuba, Fidel kind of figure, not our kind. A couple of brothers and cousins in the government. But at the same time, I'm just loath to suppose that though it's an occasion for scrutiny, that the simple fact of civilian casualties itself is a presumptive reason to attribute illegal methods of warfare. Because when you have a foe who takes human hostages and human shields, and you're trying to end the war, that's a difficult circumstance. In a way, since I don't know if Colonel Litzow, he's still here, he left, I guess. He put that little word in the Rome elements about strategic or overall purpose for proportionality. And in a way, there's almost an obverse of that. One could argue that somebody's not being proportionate if they fail to take steps that would end the war in a fashion that would minimize the long-term number of casualties, i.e., if you'd been more docile, would it have been 30 more years of war if you hadn't killed Prabhakaran? Don't know. But I do think that at the moment, there's a very human tendency, perhaps misleading, to suppose that every time civilians get killed, it's presumptive proof of war crimes and of excessiveness. And that's sometimes, alas, not true. And then final topic for my role is méchant, pupille, bad girl. I do think that our community should be looking at the issue of the responsibility of international organizations. And this is something that has been very delicate as well. I know Jane Hall-Lute, who's now at DHS and was at PKO, was for a number of years married to Doug Lute, the White House guy on Iraq, was trying to go into Eastern Congo and Southern Congo to limit the lack of remedies for the rapes of all the women there. But the question of the discipline of peacekeepers is something that even now the UN has never come to terms with. They still send them home. They may track their record of not being prosecuted a little better, but I have never heard of an instance of a UN peacekeeper being prosecuted at home for depredations committed abroad. And it's ironic that with all the debate about the US and the ICC and impunity and vacuums of this area where typically you have untrained, poorly paid, newly recruited troops, sometimes used as cash cows, that there's simply no interest on the part of the human rights community, the LOAC community, about monitoring their preparation for and discipline after battlefield misbehavior. And that's a very serious issue. The responsibility of international organizations, of course, is being examined in the International Law Commission, but I think this area of troops has always been considered no-go for fear that no one will come. But it's gotten to the point in Eastern Congo, I think, where it's past the point of neglect. And that's something, therefore, that particularly people who are involved in multilateral, multinational forces perhaps should figure out a way, even as a model for replication elsewhere, to think about tracking methods for discipline, and perhaps even some kind of multilateral discipline of peacekeepers. Because it's quite ironic, again, that with the supposed omnicompetent reach of the ICC, that this is the one area that nobody in the conversation has paid any attention to. Thank you.
Well, thank you, Professor Wedgwood and the other panelists. I must say, even though I live in a country where the coffee break is a non-derogable human right, being Italy, we do have time for some questions before the scheduled start. So if I can perhaps take 2 or 3 questions if we have those, and then invite the panel to respond. Sir.
I'm Nick Rostow. I was probably the shortest lived Stockton professor in the history of the chair, having been interrupted in my service by 9/11. This is a very interesting panel, and I have a few observations on everything that was said and a question. It's interesting about the referral of Libya to the ICC because the United States invaded Panama because of an indictment of Noriega. And now we have a situation where parties to the Rome Statute find themselves talking about, is there a non-ICC solution to Gaddafi? Get him to go somewhere so he leaves power. Of course, his incentive to go anywhere is considerably reduced by virtue of that referral. And it raises the question whether anybody can talk to the target of the referral. So it was a kind of one more mindless aspect of that, what appears to be entirely feckless operation. And I think that one of the things missing from this discussion is the politics of these events and the relationship between law and politics, and the fact that law has consequences. For example, I'd be interested in the views of the panel on whether the detention problem has resulted in fewer prisoners being taken. There's a few comments on the U.S. position at the Security Council being inconsistent, but of course one has to remember that the United Nations above all is a political animal and a political body, and that lawyers love to pick and choose statements made at the Security Council or the General Assembly to bolster their arguments, but it's not quite fair not to take into account the political aspect of the United Nations. As to Ruth Wedgwood's comment about Nuremberg and about the UN not being full employment, I'm sorry to say the UN in many respects is lifetime employment, and that's the point for people. And one needs to remember, which is never remembered, that Nuremberg had enormous resources compared to the ad hoc tribunals or the ICC. It had, after all, the full, it was not even a blip on the budget for or the cost of World War II, but it had hundreds and hundreds of U.S. Army, French Army, British Army, Russian Army people working on the cases. And let me finally make an observation about international humanitarian law and human rights law, which I would also welcome your comments on. There's a bit of a surreal quality to it all, I've felt, for many, many years, in that nuclear weapons are not illegal. And they, per se, are non-discriminatory, violate everybody's human rights, don't fit within the law of armed conflict. And yet we conduct these conversations as if they weren't in existence, as if they didn't have any impact at all. And I think that's a mistake. And finally, a question that occurred to me listening to you all was whether, had the law of the 21st century been in effect in 1860, would the United States have been able to conduct the Civil War? I'm not sure we would conduct the Civil War today, but would it have been able to do so then?
I think given that Professor Rosto's comments have raised a number of issues, we'll look to answer those and then go to the coffee break. Indeed, you could even go back an additional 80 years or 70 years, Professor, 1775 actually, and look at the impact that might have occurred in that non-international armed conflict. Perhaps if we can start from right to left, and Professor Cerone.
Thanks for the questions. Certainly a number of valid points. With the ICC referral and reducing Gaddafi's incentive to go quietly, in the resolution, the Security Council does recall the deferral power expressly. So one of the preambular paragraphs says, and remember, we can stop this. Now, granted, there's limitations on the Council's power to stop it, right? It's only for a year. It has to be renewed.
China.
Which is not necessarily a bad thing, though, the renewal, because it means Gaddafi would need to continue to be well-behaved in order to have that deferral. But that deferral could go on indefinitely. Now, we can question whether or not he would think that that would be satisfying enough to cut a deal, but at least that possibility is there, and it is expressly mentioned by the Council, presumably as a reminder. I mean, a reminder to the court, but also a reminder to would-be suspects before the court, or would-be defendants, that the Security Council still retains this power to stop the prosecution. I agree with you on the weight of Security Council and GA practice as being maybe, it's certainly not as sound as a clear opinio juris by states, because all sorts of deals are cut when those resolutions are adopted, and very frequently the reference to the application of both human rights law and humanitarian law is couched in fairly general terms. There's usually not invocation of specific obligations under those bodies of law. So I wasn't really talking so much about the resolutions of intergovernmental organizations. I mean, Security Council probably would be stronger than some others, right? Human Rights Council stuff I don't think should be regarded as at all in a calculation of customary international law, particularly on controversial issues, because that's hyper political. They don't really care that much about correspondence between law and what they're saying if you look at their track record. But when I was referring to practice of the United States, I was thinking more specifically about bilateral relations. And when the U.S. leans on other countries, like Colombia, and says, remember, you need to comply with your human rights obligations in a situation of armed conflict, that, I think, is a stronger indication of acceptance of the application of human rights law to internal armed conflicts.
I guess I should just pick one, right? Nuclear one. That was quite a potpourri, Nicky. I'll do General Sherman. Is it legal to make Georgia howl, as he said? Well, he didn't actually attack civilians too badly. He did turn them out into the countryside, and he burned down several cities with inadequate supervision of his troops. So I think you might be hard put to say he met modern standards of scrupulous observance of prophylactic law of armed conflict. But then Francis Lieber was no slouch either. When you read the Lieber Code on how you treat POWs and saboteurs and francs-tireurs, he was much tougher. He said, take prisoners if you can, if it's convenient. So he was an Air Force guy before his time. And finally on nuclear, I'm not going to do nuclear, Nuremberg. I don't care how many minions they had working for them. It was a short trial. They kept it simple, stupid. They allowed hearsay in. What was it? Was it 90 days? It was very, very short, and they knew how to try a case. And where these convictions have become surrogates for a broader idea of responsibility, because there's no tribunal on state responsibility for armed conflicts. This is it. It's so important to have it resolved in the form of a verdict. And that's where I think, again, it was just the Milosevic trial, though tried with earnest hearts and stalwart shoulders, had a very poor architecture and should have been done simply and stupidly and divided up the verdicts. And I used to think it was Carla Del Ponte who had made them do it, but it wasn't her. They should have done Kosovo and Bosnia and Croatia and gotten separate verdicts and put them in their kit bag and taken them home one by one before he died and before Richard May died. So this may be the conflict civil law versus common law sensibilities, except many of the prosecutors were common law. So maybe it was the confusion of trying to craft a Uber procedure that made things go so slowly. But speed is up. I guess like in military law, as in military music, as in military operations, speed should be of the essence, right? Shock and awe. So.
Thanks very much. First, in response to something that Ruth said, I'm not disagreeing with what you said about peacekeepers, far from it, but there have been cases of states prosecuting their own, but only where there was a significant degree of publicity attached to what had gone on. Morocco has prosecuted officers from DRC, and I understand that Argentina has as well. But I think they're the exceptions that prove the rule. I can give you a very large number of examples where people who have been detained pending investigation then mysteriously find their way home even though their passports have been removed from them. In other words, all sorts of state complicity in it. On the issue of whether the problem of detention has meant fewer prisoners, I think in one sense, yes. In another sense, no. I don't think this meant they shot them instead. But they failed to detain people they would like to have detained and could have detained because simply it was going to be too much hassle. I think there was a stage in Iraq and most notably in Afghanistan where it was just too complicated early on, so they didn't bother, whereas now that they've actually got ad hoc systems in place, that the system is more regulated. On your point about law having consequences and needing to take account of the political implications of law, I think there's an interesting difference between IACs and NIACs, and between individual proceedings and interstate proceedings. Where a state is bringing a case, including before a human rights body, based not simply on the violation, but also for a domestic political agenda, so Greece and the UK over Cyprus, Ireland, the UK. I'm not suggesting there weren't violations, but there was also a domestic dimension to the bringing of the case. In that case, there's a pre-existing political problem, and the case certainly won't help it and might aggravate it. But where you get a group of states for no domestic political benefit bringing a case, as happened in the case of the Netherlands, Norway, Denmark, Sweden versus Greece, and France, that was a surprise, Norway, the Netherlands, and Denmark in relation to Turkey. There, I think it wasn't political because they didn't bring it for a domestic political agenda except the respecting human rights agenda. It wasn't a sign of a pre-existing political problem, and I don't think it seemed to create a political problem. So it may suggest that erga omnes proceedings brought by a non-victim and individual cases may be less politically problematic. I don't think that enforcement usually itself creates a political problem, but I think it can often be a symptom of a pre-existing one. For example, the litigation between Cyprus and Turkey, it's just war in the courts instead of war on the battlefield. So there, it's an ongoing part of a pre-existing political problem. So I think there's an interesting interplay here.
And with that, I think we'll adjourn for the coffee break. If I could ask you to be back at 10 o'clock, please, ladies and gentlemen.
Depends. I don't know if they'll. I mean, often immediately after the first one. And I don't know that anything dramatically provocative. If someone wants to take the old-fashioned line, yes.
So, ladies and gentlemen, if I could ask you please to keep your return to the auditorium to a dull roar, we will carry on with the panel discussion. We have an hour in terms of time to cover. Of course, that's not obligatory, but can I ask that if you do have an observational comment you wish to make, that you keep it as brief as possible in order to allow others to have an opportunity to pose their questions as well. And if I could also ask if you could identify yourself if you haven't asked questions previously, just so that not only ourselves here, but those who are watching in the remote conference room are able to identify who it is who's asking the questions. So as I mentioned before the break, we'll go with 2 or 3 questions and give the panelists then an opportunity to consolidate their responses. So, who would like to go first? Professor Walker.
George Walker. With respect to, I'm going to speak to Françoise about this, with respect to your civil or private remedies, I think one thing that needs to be pointed out is that if you go before an international tribunal, you're going to have to exhaust local remedies unless they're futile or a treaty waives them for you. The other thing is that there is sponsor discretion, and that is of the state to take it up to go before certain tribunals, and sponsor discretion to, in the espousal method, to how much you're going to get paid. I think, lastly, is the fact that very often when compensation is paid, whenever it's paid and however much it's paid, it's frequently ex gratia. So you have the problem then of, if you will, no feeling of vindication, so to speak. It's very much like the car accident out in town, you know, no admission of liability and so forth.
Thank you. Professor Van Heinek.
My question to Françoise is following up to what George has just said, but an additional aspect. When it comes to the exercise of the right of diplomatic protection on an interstate relation, the question would be, what could the state claim? And wouldn't it only be the minimum standards, the so-called minimum standards, that would be claimable under the right of diplomatic protection? And the other question would be, if in front of an international tribunal, human rights violations would be claimed by one state vis-a-vis or against another, would the argument of a self-contained regime have any significance with regard to the claim, meaning that human rights violations can only be claimed in front of those bodies that are competent under, for example, a regional regime, like, for example, the European Convention of Human Rights? The second question is to Ruth with regard to international responsibility of international organizations. In theory, yes, I think it would be one remedy. However, if you look at the comment of the Special Rapporteur on the draft articles of the ILC, you will see that he has a very clear understanding of what placing at the disposal of an international organization means. So the cases in which the international responsibility of an international organization would really come into play would only be if you have personnel proper of the respective international organization. And the fact that within the European Union there may be a trend into another direction, I think is nothing you can take for other examples, because the European Union is a very special international organization. So I don't see much room for the international responsibility of international organization when it comes to alleged violations of either human rights or IHL in armed conflict situations.
Thank you. I think we'll go with those 2 questions, and I'll return to the 3 people who've got their hands up after the answers. Professor Hampson.
Thanks very much. First of all, on the question of exhaustion of domestic remedies, yes, before you go to any international tribunal, including as an individual complaining against a state, you must exhaust domestic remedies, but only if they are potentially effective. There's a lot of case law on what that means in practice. For example, if prosecutors fail to investigate things as a result of which it's not possible to bring a claim domestically, then that will be a reason for saying you don't have to exhaust domestic remedies. If you're likely to be subjected to pressure on account of your application or in the process of seeking to exhaust domestic remedies, that also will be a reason for saying you don't have to exhaust them. It was one of the really major issues in the litigation against Turkey arising out of southeast Turkey, because in the majority of cases, traditional exhaustion of domestic remedies had not taken place. The leading case on exhaustion of domestic remedies is the Akdivar case against Turkey. On the issue of sponsor discretion, of course, if an individual is bringing a case in their own name, then they don't have a sponsor. They have a legal representative who's got obligations towards his or her client, but there's no issue about choosing whether to take it up. That issue only would arise when a state is deciding whether or not to bring a case. And there's an interesting, there was an interesting development a long time ago. The UK announced that in any case that they might otherwise have invoked state responsibility to complain about harm done to a British citizen, that where the state in question had accepted a right of individual petition, the UK would require the individual on their own to bring an individual complaint. So there was a drawing back, in some cases, of diplomatic representation in those circumstances. As far as ex gratia payments is concerned, that is simply not an issue when a human rights body delivers a binding legal judgment. It's only an issue in the case of friendly settlements. So where there is a settlement, then both sides maintain their legal claims, but money may change hands. Once the court has, particularly the European Court of Human Rights, once it has determined that a sum has to be paid, then that sum has to be paid. Because since this is a binding legal judgment, and since the Committee of Ministers secures enforcement of the judgment, that's the first thing they get enforcement of. A tougher job is getting enforcement of the general measures needed to redress the situation. But for example, Russia routinely pays on time on the Chechen cases, so they're not even paying default interest. Turkey never paid on time, which was greatly in our interest, so long as they used a rate of interest that was higher than the inflation rate. I think Turkish citizens should complain because the Turkish taxpayers suffered as a result of Turkey's protracted delay in paying in particular legal costs. As far as Wolf's question was concerned, and the issue of diplomatic protection, I think the closest case I know in a human rights context there is that Denmark-Turkey case, where what happened was a Danish citizen of Kurdish origin, whilst in Turkey, had allegedly been tortured. The fact that the case was actually submitted by Denmark didn't make a difference to the essence of that complaint. Where it did make a difference is Denmark said that torture was occurring as a matter of practice. And that issue of practice, which has an effect on the requirement to exhaust domestic remedies, and once you get into the substantive violations would have an effect on what's needed to redress it, doesn't seem to be capable of being raised in individual cases. That possibility was left open in Donnelly, but it seems to me the Kurdish litigation suggests that that can't be raised in practice in individual cases. So the human rights question that would be raised, in a sense the state would be standing in the position of the individual. So it's whatever the relevant complaint is. In the Danish case, it was torture, cruel, inhuman and degrading treatment. Well, inhuman degrading because it's the European Convention. But if it had been someone who was complaining about being burnt out of their home, then they would have been arguing the contents of Article 8 and Article 1, Protocol 1. So it's the content isn't going to be some minimum content. The content is going to be determined by the content of human rights law. On the question of international tribunals and self-contained regimes, I think, if you like, again, that train has left the station. In that in DRC and Uganda, for reasons that are completely unclear, the ICJ found the same acts to be a violation simultaneously of Article 51 of AP1 and Article 6 of the Covenant. I can understand why the ICJ has given up giving detailed reasons, because if they want to get anything approaching a majority for any proposition, they've got to keep as vague as possible how they got there. But it does mean I haven't got a clue as to how they did it, particularly outside Ituri. Ituri they regarded as occupied, plenty of case law, and occupied territory, human rights law applies. But the bits that weren't in Ituri, what about extraterritoriality? Nobody raised it. Where were the rest of the international community seeking to submit something like an amicus brief? There weren't any. Again, I think it's a dereliction on the part of states. I think at the European level, where it's easier to deal with things legally without it acquiring a lot of baggage, I think an extraordinary failure has been in the absence of use of the Steering Committee on Human Rights, which is composed of diplomats. They're not like ambassadors, it's sort of lawyers from foreign ministries, and also the Committee of Ministers. The big issues, Can you derogate outside national territory? Can you rely on another state's derogation? To what extent should the court take account of the law of armed conflict and how? All you need is the steering committee to commission a report on those issues, to have a discussion about it, make a recommendation to the Committee of Ministers, and get them to pass something like a declaration. They shouldn't seek to bind the court, because in that case the court will be bloody-minded and say up yours. But what they can do is say, we are willing to accept the notion that we can derogate extraterritorially, or we're not willing to accept it. But say something about it. They're not assisting the court in operationalizing the relationship between human rights and IHL, and they could do. There are plenty of opportunities for them to do so. And so I don't think the self-contained regime will work anymore. I think I think it could apply where it's res judicata. If you have got a judgment of the Inter-American Court of Human Rights, the European Court of Human Rights, and the parties to the case try and take the same case to the ICJ, which raises a question about Ecuador and Colombia. At least in Georgia, Russia, it's a different case. The only basis on which they claim the ICJ had jurisdiction was the issue of ethnic discrimination in the ICJ, whereas before the ECHR, it's the full conduct of the war. So there could be a res judicata issue. However, I note that some states, in accepting the jurisdiction of the Human Rights Committee under the optional protocol, have not required their citizens to choose. Some have said you can either go to a regional mechanism, e.g. European Convention on Human Rights, or the Human Rights Committee. Others haven't required them to choose, e.g. the Netherlands. So in that case, they presumably don't mind being judged twice. I assume that nobody would go twice if they'd won in the first place. The reason why you'd go to the Human Rights Committee is you didn't win in Strasbourg. So it still means that applicants are getting two bites of the cherry. So I think this issue of self-contained regimes doesn't work, but I think the res judicata point, where it's a binding legal judgment, could raise an issue.
Professor Wedgwood.
Perhaps I don't feel as immediately bound by existing New Haven trends as others might. There ought to be responsibility. I mean, my paradigm case from Rwanda, when the Ghanaian, and I've forgotten what was the other country, but the troops ran away from the front doors of the culture minister and the chief justice, am I remembering right? And home of the culture minister. And this plucky little Australian, bless them, Michael Horrigan, brought a claim for dereliction of duty. And Hans Carell ruled that you could bring private law claims if your cow got killed, but you couldn't bring a claim sounding in public law. So Horrigan then restyled it as a private law claim, and I don't know what happened to it after that. But it did seem to me that for all understandable reasons, back when the delicious, wonderful Manfred Eisel was head of planning in PKO, that people just felt obliged to turn their heads because that's all they had, and they couldn't be picky about troops because otherwise they wouldn't have any troops. They had no money to train. They had no money for after action. But it was in the midst of the ICC conversation, shall we call it, it was quite ironic that the UN was being taken to task very severely for having sought immunity in various kinds of deployments, and yet all the UN peacekeepers were functionally immune. And that just struck me as an anomaly. If you should be consistent in the omnicompetence that you would like to attribute to tribunals, and by the time the wench is dead and the guy gets home, no one brings a case in general. I think that's fair to say. And it struck me that I think Eisel actually did begin to track repeat offenders. If he had I won't name any region, but that'd be a hypothetical region from a naughty country that he might not ask them back. But there was no felt political capacity to push very hard for discipline in country, just to try to minimize the damage. And that is really not consistent with the current ethos in war crimes prosecutions, I think.
Perhaps there's a call for one of the human rights organizations to run www.peacekeeperaccountability.com. Madam, the lady at the back. Yes, please.
What are the laws that apply for detention?
Thank you. Professor Murphy, you were next.
Thank you, Mr. Chairman. I must say that you're wise to put constraints on questions and comments because we could go on for hours and hours. There's been so many issues that have arisen. Just by way of comment, I certainly will associate myself with Nick Rostow's point, and I think Ruth Wedgwood's point, that it is important to keep in mind the political aspects of all of this. Because otherwise we as lawyers are operating in a very unrealistic world. I have brief questions for all three panelists. In John Cerone's case, I was mentioning to him during the break that Libya, of course, is supposedly an exercise of the responsibility to protect. And speaking of political factors, I think it's important to note that those 5 abstentions that he referred to the Security Council resolution came about only because of the unanimous view of the Arab League that Gaddafi should be dealt with. Otherwise, it's clear, I think, that the Russians and the Chinese would have blocked all that. My question to John is, that does the responsibility to protect, if this is an exercise of responsibility to protect, does that include to protect in an effective manner? Because it seems to me that whatever else one can say about the Libyan situation is that civilians are getting killed more and more, both by Gaddafi's forces and by, indeed, the rebels. My question to Ruth Wedgwood is, Ruth, I was interested in your sort of offhand comment about the desirability of the Universal Periodic Review. My question is it your impression, and is there indeed any examination of whether the Universal Periodic Review actually brings about changes in the human rights practice of the states that are being reviewed? Because my impression is there's precious little, if any, certainly in the case of China, just to give one example. And then finally, for Professor Hampson, I think your point of putting more emphasis on civil suits as a method of enforcement is right on. Indeed, I've done some writing on this myself. My question to you is, are you optimistic that this can be an effective enforcement mechanism? Because it's been very spotty, as I think some of your comments indicated. And I do sense a variety of obstacles, and I've examined some of those obstacles myself to this coming about. Thank you.
Thank you. We'll take one more. Pedro, please.
Yes, my name is Pedro Fonseca. I'm from Defense Command Denmark. My question is to Professor Hampson, and it concerns the issue of derogation from human rights. In order for a nation to derogate from derogable human rights obligations, it takes a state of emergency threatening the life of the nation. You might say that it doesn't really matter whether that threat comes from within or from outside your own territory. However, when it comes to the participation of a state in a third nation's NIAC, it becomes an odd situation. Let me take an example from a Danish perspective. Denmark participates in ISAF in Afghanistan. Let me stress that Denmark has never derogated from human rights obligations. However, if we should consider a need to do so in Afghanistan, say in relation to detention, we would have to be able to argue that there was such a threat to the life of our nation. However, I consider it that we can hardly say that this could be the case in situations where we are assisting a host nation in its own NIAC, as it's not our nation that is threatened. It's rather the life of Afghanistan's nation. Nevertheless, I understand that some of our coalition partners have already derogated once or twice in relation to in the same context. I think that we can hardly ignore the material criteria for derogation, as derogation is a very serious matter. So I'm wondering whether we are looking at a real legal challenge here, or do you consider this problem to be more academic in character? Thank you.
Thank you. So the three areas we have are private military contractors or private military security companies and accountability of them. Three questions posed by Professor Murphy on Libya, periodic review, civil suits, and then the last question in relation to derogation from human rights obligations. I'll ask Professor Cerone to start.
For private contractors, I guess the short answer is they're civilians except when they're not. If they're incorporated into the armed forces, they're not. But generally, they're civilians. And of course, if they're directly participating in hostilities, they lose their immunity from attack. As civilians, they also don't have a privilege, so they can be prosecuted for their violent acts. So they would have possibly a self-defense argument if their life were imminently in danger. But they certainly don't have a privilege if they're civilians. On the Libya resolution, I agree. The Arab League call for the use of force was key in that decision, and certainly would sway the 5 reluctant states to abstain instead of vote no on the resolution. And why did the Arab League take that position? Of course, there's all sorts of ideas about that. Most people just say it's because they all hate Gaddafi already, so it was a very easy political target. And also perhaps officials in the Arab League may have their own agendas, but in any event, once that communique came out, it was a lot easier for the Security Council to then proceed with the imposition of the no-fly zone and the more robust protect civilians mandate. Does R2P include responsibility to protect in an effective manner? In a common sense way, yes, I suppose it does. At the same time, I think international law generally cuts more slack to states when it comes to positive obligations than negative obligations. So yeah, clearly it would be a problem if the multinational forces were intentionally targeting civilians. But I think there is going to be, at least the tolerance allowable under IHL for mistakes, and perhaps even greater tolerance in this context.
Professor Wedgwood.
First, on the contractors, I assume you're probably thinking of that charming Blackwater shooting in Iraq, which got completely messed up because there was extraterritorial jurisdiction, but the State Department saw itself as the contracting agency, interviewed them all, gave them all immunity, which created use of taint problems, and the case was hash, and very undesirable. Because contractors don't go through the same rigorous training necessarily that American armed forces do, and may have a sense of largesse in their activities. And we're going to rely on them more and more. If Bob Gates' force structure for Iraq goes through, it's what's going to be 10K American troops and 30K contractors. And you therefore better have them be under some form of effective discipline. There now is the criminal jurisdiction. I think state has learned its lesson. I would assume probably there'll be a couple of emblematic prosecutions at some point in the future. And Eric Jones, was that his name, the Blackwater guy? He's now reincarnated himself as X2 and is setting up his new private arm, 2X? Z2, whatever. It sounds very spacey. And setting himself up as a new, sort of the new Marlon Brando figure in the UAE. And just one little other, soon to invade the U.S., I'm sure. Just not my topic, but just on Libya. The question I would have asked Harold yesterday if he'd called on me was, indeed, you can't leave the guy in power. I mean, it seems obvious at this way. If he didn't like you before, he doesn't like you now. And shades of Lockerbie, and shades of the kid. So we really have to finish it. We can't just say, 60 days, bye. So where are we? my worry is that because the administration's approach is to sashay around the War Powers Act, just go damn it, ask Congress and put their feet to the fire. But if you're tiptoeing around it by saying we're doing this but not that, we don't drop bombs, we just supply them, it's a kinetic non-operation, that we will not have the gumption to finish the fight the way it needs to be finished if you're going to keep Gaddafi from being a continuing threat to his own people, and even more the region and all of his prior adventurism abroad. So it's one case in which I don't know the politics which impelled this tippy-toe approach, but it would have been much cleaner to go up there and make his case and get a resolution, and or else just done what George W. Bush might have done, which is to use the savings clause at the end of the War Powers Act, which says that if anything in this act would otherwise impede on the constitutional authority of the executive branch, it doesn't apply. And use the savings clause and say, you know, belt and suspenders, I've asked you nice, I'll interpret your mandate broadly, and in any event I can do it. But I do think that the sort of neurotic half-legalisms will ultimately serve as an excuse to limit what we do, and therefore perpetuate or create a very dangerous situation. Because the more I fell in love with Muammar, the more I became admiring of his ambition to make hay in Chad. He was stirring up Chad. He brought you Sierra Leone, Cote d'Ivoire, Guinea-Bissau. And at one point, I'm given to believe there's at least one prosecutor at a war crimes tribunal somewhere in Africa who might have considered framing an indictment for him, but backed off. He should have been indicted a long time ago.
Not to mention bringing Scotland-US relations to an all-time low. Professor Hampson.
On the issue of the status of contractors, I think there's a range of separate questions that arise depending on what your issue is. If it's simply their status in a field of battle, then I agree with what John said. If you're looking at the circumstances in which they can be sued, that's going to depend, first of all, on the rules of civil jurisdiction in different states, and also on whether they've got any form of domestic immunity if the contract is with a government. When it comes to state responsibility, in the usual circumstances, it is possible that the state may be responsible for the acts of a PMSC, but even where the state is not being held directly legally responsible, if the state has given a contract to a PMSC where it's carrying out an intrinsic state function or the exercise of sovereign powers, and I would argue that detention is such a thing, then the state may have direct obligations irrespective of who's delivering it. So instead of only having the obligation to protect people from harm done by non-state actors under human rights law, they would be directly responsible, not for merely a failure to protect. On the question whether civil suits can be effective, I think there are two different kinds of obstacles. There are those obstacles which are the accidental result of history and because the initial focus was just within the territory, in which case states may be willing to seek to remove those obstacles. Insofar as the obstacles are there because states don't like being sued, they're not going to change. The fact that proceedings can be brought before human rights bodies conceivably could make states do some things that they wouldn't otherwise like to do. In that if your dirty washing is going to be washed, whether you like it or not, and you've got a choice of it being washed internationally or washed domestically, you might say, well, I don't like the idea of there being accountability, but I'd rather it happened here, which is basically why the UK, in the end, incorporated the European Convention on Human Rights. So that might nudge states a bit in the direction of accepting things they otherwise wouldn't like, but I think there are bound to be challenges there. I think if it weren't for the defects in the bringing of civil claims, you wouldn't have seen so much use of human rights machinery in effect to enforce the law of armed conflict. On the issue of derogation, basically, I think, and here I think one needs to take account of political considerations, small p. Basically, what do states want? It's not they can have whatever they want, but they've got all sorts of options. Under the European Convention, unlike some of the other treaties, the formula is war or an emergency threatening the life of the nation. So it expressly includes the possibility of war, which in 1950 meant international armed conflict. And there's no doubt about that. There's also either you can derogate or you've got a defense with regard to lawful acts of war in relation to Article 2, the prohibition of various forms of killing. So it was clearly envisaged that it would apply in those situations. I think it's true that no state has ever derogated on account of a situation external to that state. So they've never derogated even if they thought there was a threat to them from outside. That hasn't been the basis for a derogation. They've only in practice derogated in relation to situations internal to them. And in some striking cases, states have not derogated. Russia hasn't got round to derogating. Whether that's ignorance, incompetence, or what, I'm not in a position to say. But the options include, one, saying that we don't think, we're not going to derogate, we don't think we should derogate, but then indicating to the court that because the law of armed conflicts applies as a matter of law, it isn't an elective thing like a derogation. So it would be possible for the court to take account of the law of armed conflicts simply because it is applicable. And you don't need to get into the issue of derogation. Another option would be, as I suggested, if you'd got some kind of, not a resolution, but if you'd got a declaration from the Committee of Ministers that they would, that they think that it is possible for a state to derogate on account of an emergency in another state where they are assisting the other state, then I think the court would be grateful for the steer. At the moment, they don't know what states want them to do. Another possibility would be for them to say that when a state is assisting a third state, and that third state has derogated, they can rely on that third state's derogation. Now, this could get a little complicated because if you take the Afghan example, if the United States would allow Afghanistan to derogate, which at the moment they're not allowing them to do, then it would mean that you'd get a derogation to the covenant being relied on in the European Court of Human Rights, which would be slightly peculiar. But basically, it's up to states to say what they want. If they don't give any kind of steer, then they can hardly blame the court if the court then comes up with something they don't like. And what is completely unacceptable is the current attempt to blackmail the court. In the Bankovic case, the United Kingdom, on behalf of the 17 respondent governments, said, if you dare find this case admissible, we'll never turn up to any kind of peacekeeping or anything like that again. And they did the same thing in Bahrami. That isn't giving guidance to the court. So I think that European states are behaving with a lack of responsibility in this area. There's all sorts of ways in which they could create the option of derogation, whether it's vicarious derogation or allowing it or what. But at the moment, they're just not doing anything.
Professor Wedgwood's asked a brief riposte.
In senior absent-mindedness, I forgot to answer John Murphy's question. If there is an answer, there's no answer. But it's on television. And it had always been my romantic hope that one day some young person in Guinea-Bissau saw his government having to answer a question. He'd be thrilled by that, whatever the answer was. And I haven't got traffic information from the UN television website, but the treaty bodies are very envious of the kind of Hollywood extravaganza that the UPR has. And I guess the shock to me when I first got to Geneva was just that we were so bad at staging our own work. We would do Belgium every 4 years, searching for issues. Well, so sometimes nice countries have issues, like the Swedes have a lot of involuntary electroshock therapy, and the Dutch tend to use euthanasia too freely. So there were things to find, but still we did Belgium every 4 years, and we never got to 40 countries in Africa and Asia. And we could have taken them up without them reporting by scrapping together available information. Then they'd show up. We did 1 a year, 2 a year of those. So I think UPR, just as a matter of discipline, of getting countries interested in the phenomenon of being self-attentive. Because the other thing that, the final comment just of my wayward past decade, you discover many countries just are not transparent to themselves. You can ask them how many people you have in jail. They don't know. How many people in jail have AIDS? They don't know. So this idea that you can have any real kind of modern administrative panopticon reporting in most countries ain't true. So UPR is better than nothing. It's very hortatory. But some annoying critic will slip in between the traces and allow them to know that. conscience is a little voice that says someone might be watching. So.
I think anyone posted to SHAPE would have heap to say about Belgian and human rights. Professor Watkin.
Françoise, you said it this morning, I think Knut said it yesterday, that human rights law is more detailed and clearer than IHL. It's hard to get clearer and more detailed than either the Geneva Convention or the POW Convention with respect to internment and such. But I just wonder if you could sort of tease that out a bit. Historically, it seems to me human rights norms were always part of IHL. Human rights norms and human rights discussion really forced AP1 and Article 75. And then around the late 1990s, out of Europe came the Bankovich case that talked about, in a serious way, whether human rights norms were extraterritorial. And I just wonder for non-European states why they might look to the European court, which always seems to be brought out as sort of the basis for many of these norms, as being indicative that as a result, it's a treaty court. Some ways seems to be narrower than international human rights law, the Universal Declaration. It's certainly narrower than, say, under Canadian law with respect to the use of force that we have in our legislation and some of our law enforcement provisions. It may or may not be narrower than the U.S. And just in terms of the European court itself, again, a treaty court, which seems to have trouble calling an armed conflict, such in Chechnya, seems to have trouble applying IHL at all. And in terms of trying to sort of convince the non-European parties to the European court, where is this source of clarity in terms of what actually human rights law is? And I think it's come up in various points during the conference, whether Ruth mentioned it yesterday with respect to the civil law approach to detention versus the common law approach to detention. I think Bill Lietzau hinted at it as well. Bill Boothby talked about it with respect to the use of expanding bullets versus other countries that don't use expanding bullets. And as we go forward, the train is out of the station. I guess it's just a question of adding clarity to the discussion and how much the international standards of human rights will do that.
Thank you. I think we'll go for some more questions, although I would add a editorial. Yeah, no, that's fine. I'll just offer some opportunities up. Was there someone up here? No, and there was just one lady. Yes, Penina.
I would like to hear your opinions on three short questions. The one is the tension between prosecuting war criminals and reconciliation efforts. Second would be the issue of procedural rules for fact-finding bodies. And the third would be the issue of accountability of states assisting non-state actors in carrying out war crimes. Thank you.
There's the best case example of questions. Charles, hard act to follow.
Thank you. My question is actually to Ruth. I entirely agree with your critique of the Goldstone report and of sort of ad hoc inquiries. I am wondering whether there is any merit in looking again at the much maligned and never used Article 90 International Humanitarian Fact-Finding Commission and seeing whether that can be revived and perhaps encouraged. I have to declare an interest.
Yes, Charles is upset that he can't get on the UN bandwagon of employment. There was another question I thought over here. Alexander, please.
I'm Alexander Porechkin from Germany. My question relates with applicability of IHL. Can soldiers reduce their own risk, not the risk of the mission, their own risk by running a higher risk of collateral damage in the civilian local population, if they respect to be not excessive?
Right, thank you. I think we'll carry on with some answers to those questions and then allow another round before we finish. So if I could ask the panelists, therefore, to just keep their remarks as pointed as possible to answering those questions. Professor Cerone, would you like to head off?
guess I'll start with the question about states assisting non-state actors to commit war crimes. Were you asking about modes of responsibility for that? I mean, certainly on an individual level, there's complicity if they're merely assisting. Of course, if they're calling the shots, there's the possibility of more direct forms of responsibility. On the level of state responsibility, it's a question of attribution. Well, if the state is to be held directly responsible for the conduct, you have to show that the conduct was attributable to the state. But short of that, even if the conduct itself is not attributable, the state's responsible for its own conduct in supporting it, which would likely be a violation of other rules of international law, depending upon what the conduct was. If it was conduct against another state, I'm thinking U.S. and Nicaragua. There, the U.S. was found to have, through its support to the Contras, even though the conduct of the Contras was not attributable to the United States, its support of the Contras was still a violation of non-intervention and the prohibition on the use of force.
Professor Wedgwood.
First, just, I guess, going backwards to Ken Watkin. I took Bonkovich and also, frankly, the ultimate decision in the genocide case to be just motivated by the uncomfortableness of having the shoe fit another foot. What goes around comes around, and when you start applying IHL, it applies to you too. And so it certainly never occurred to anybody that when you set up the Yugoslav tribunal that NATO would ever be investigated. So Louise had to go way out of her way with our friendly Canadian JAG to find that it didn't even rise to the level of warranting an investigation. And the ICJ had to do backflips to show that Serbia could not be a defendant and therefore couldn't be a plaintiff suing NATO, and therefore later it couldn't be a defendant really in the genocide case. And Bonkovich, same meme. So I don't take them as evidence of much more of a much larger principle than it's uncomfortable to get prosecuted or investigated. On the Garraway suggestion, my favorite older Dutchman, whose name I'm blocking on. Yes, Fritz. He ran that for a while. Is an empty shell, didn't he? He was a wonderful. He is a wonderful man. And he would certainly agree with you about that. And I think there'd be greater confidence in even-handedness in that kind of a setting than in a hydraulic UN setting. But who'll be the first one to gamely take part, I don't know. On the wonderful compendious list of questions from Madame in the corner, where shall we start? I'll leave 1 and 3 for other people, but on 2, rules for fact-finding bodies. I do think fact-finding really is the Achilles heel of most of international work. The ICJ is no good at it. The war crimes tribunals are somewhat better, but because Richard Lillick wrote a book on fact-finding, didn't he? But I think there's been too much attention to law and too little about what good protocols for investigation are. And and frankly also just the revisory proceedings and procedures you need to have available. One thing that drove me nuts in Geneva is if we got something wrong, there was no way to correct it. A state couldn't appeal from a rank error if we happened to make one in the rush of work, because if you did so, then everyone would want to do so, and that was too much volume. And I think any kind of fact-finding procedure that doesn't have a motion for reconsideration to allow correction of palpable facial errors is one that will not have this kind of confidence that you need. And I also just think that, again, the secret of good... Well, when I was an arrogant little Yale graduate like this new chiefo here, I thought law was everything and facts were beneath us. We were Yaleys. And then you learn that the facts are the most important thing and much more elusive than law. And therefore, I would train up many more international lawyers who are really good fact finders. And finally, on the preferring self-protection to protecting civilian actors, I'm not going to answer that question, but just a brief mention about a kind of separate proportionality, which had never occurred to me. I went to our campus in Nanjing, and somebody was telling me the story of how the Chinese beat back the Japanese. At one point, they opened the dikes to the Yellow River, and they drowned 1 million Chinese, but the Japanese couldn't advance, good news, bad news. And the issue I never considered was whether there was a kind of proportionality that you owe to your own civilian population in self-defense. Could it be a war crime to sacrifice too many of your civilians merely to win a war?
Professor Hampson.
Taking the questions in reverse order, I'm sure that you know that in the Journal of Military Ethics, my colleagues in the law school object to my having a subscription to that. They think it's an oxymoron. The Journal of Military Ethics contained a famous article by two Israelis on precisely this issue being debated philosophically, and the next issue was entirely devoted to the response they got to the claim. I think there is an oddity in the wording of Additional Protocol 1, because on the one hand, it says that the harm to civilians and civilian property must not be excessive in relation to the concrete and direct military advantage anticipated, and on the other hand, it speaks of minimizing civilian casualties. I don't know if I'm using minimize in a strange way, but my understanding of that word is minimize is reduced to a minimum. Well, that isn't the same as should not be excessive. I think the general approach to the proportionality formula is that it shouldn't be excessive. Therefore, on condition that the total number of civilian casualties is not excessive in relation to the concrete and direct military advantage anticipated, I don't think you would have a problem, even if they could have been lower, if you'd undertaken more risk to your own forces. On the question about procedural rules and fact-finding, I think there's two different things at issue. I'd assumed that what you meant was the obligation to investigate contained within human rights law, as opposed to fact-finding carried out maybe in the context even of human rights cases. One of the problems of arguing for the any form of applicability of human rights law in situations of conflict, even if they take account of the law of armed conflicts, is the development of a significant body of case law requiring various things to be investigated. They are particularly serious human rights violations. So it's alleged unlawful killings, alleged disappearances, and allegations of torture. If they are going to maintain that in situations of conflict, someone needs to spell out in words of one syllable that attempting to find the facts in a situation of armed conflict is far more difficult than in an ordinary peacetime situation. That's particularly true in an NIAC if you're not actually in your own territory. What's more, merely because journalists can get people to talk does not mean that the state investigators turning up in military uniform are going to get people to talk. So some recognition of the practical difficulties would be useful. If it's how do human rights bodies conduct fact-finding, the precondition is cooperation of the state in whose territory they're carrying out the investigation. It's one of the reasons why the European Court of Human Rights had to pull out at 48 hours' notice from an investigation not about the Chechen conflict, but the investigation of a case involving Russia somewhere around Ekaterinburg. And it wasn't the Moscow authorities, it was the local authorities who refused to cooperate. So the European Court of Human Rights charged Russia with all the non-refundable costs for things like interpreters for having made it impossible to fact-find. Turkey semi-cooperated with the fact-finding hearings. Where you haven't got effective exhaustion of domestic remedies because the domestic remedies system is a complete load of garbage, then in fact the human rights body has to be the determiner of fact and has to have the means to fact-find on its own behalf. On the issue, because nobody else has addressed it, of the tension between prosecution and either reconciliation or finding an end to the fighting, before we actually reconvened, John and I were talking, and we reached the conclusion that what Gaddafi should do is say he will give up power on condition he can go to the United States because there's least likelihood of them ratifying the Rome Statute and cooperating with it. I think you could really develop quite an interesting trade because you could charge quite a bit if you became a safe haven for all these nasty bad guys. Quite where you'd put them is interesting. Well, there's various islands, notably off the coast of California, you might want to think about. On the question of how detailed human rights law is, when you're looking at human rights law, you don't simply look at the treaty text. You look at the development of consistent case law over time. And because of the volume of cases submitted to it, there is a very detailed analysis and understanding of what rights are involved, particularly in the case of something like detention, in both the European level and the Americas. It would be the amount of case law only on the issue of detention is wider than I can stretch with my arms. So it has addressed issues, very, very specific issues, like the circumstances in which your access to an interpreter needs to be free, and whether you can charge them after the event or whether you can't charge them at all. It's had to address issues like lawful authority and separately grounds of detention. It's addressed internment. It is perfectly possible to intern under the European Convention on Human Rights, but you need to derogate because of the wording of Article 5. It's addressed all those issues and indicated what it expects. So you know what the normal framework is. The point then is, what can you derogate from? And you can derogate from the various aspects of the rules on detention. And how do you justify, one, the derogation and the specific thing from which you are derogating? The provision most frequently derogated from is Article 5.3, which is the provision on being brought before a prosecutor within a reasonable time. The world and his mother in Europe have derogated from that and made it a bit longer than it would otherwise be. It's taken for granted. So it's not that there is vagueness and uncertainty. You might, if you only read the treaties, then you're not going to get a clear idea of what it is. But if you look at the case law, then I think there is detailed and specific case law. But it's not just at the European level. The inter-American system, in my view, is the one that so far has most clearly and most effectively dealt with the relationship between human rights and the law of armed conflicts. That's what makes it peculiarly ironic that the US, that comes under its authority only with regard to the OAS Charter, so it's only under the authority of the Inter-American Commission on Human Rights, makes it odd that the US won't cooperate with it, for example, in the Guantanamo case, because that's the one body that does take account, when applying human rights law, of the applicability and the relevant content of the law of armed conflicts. The problem at the European level is that historically it had dealt with situations that the ICRC would have regarded as non-international armed conflicts, but where the state chose not so to label it. Because the state was not calling it an armed conflict, because they didn't want the external attention that would provoke, the state could hardly then say, oh, by the way, we've got an armed conflict going on. So states weren't using the law of armed conflict, they were using derogation instead, e.g. Northern Ireland, e.g. Turkey, e.g. the other states that have derogated with regard to specific emergencies within their territory. So part of the problem is states haven't raised it. The one time when it could have been raised, an old case that is much neglected, I bet the members of the then European Commission on Human Rights, the majority of them will be grateful, is the complete load of rubbish that the European Commission of Human Rights came out with in the first and second Cyprus-Turkey cases. The majority said, well, Turkey could have derogated, but Turkey didn't derogate. We'll look to see whether they, even if they didn't tell us, did they do anything domestically? No, they didn't. So we will apply the European Convention as it stands, and that means you can't detain prisoners of war. A minority said, excuse me, this is completely stupid. As a matter of notorious fact, there's been an international armed conflict. The law of armed conflicts was applicable not by virtue of derogation, but as a matter of law, and it is clear that in an international armed conflict, you can detain prisoners of war. So that's the only time when they've addressed it squarely. They are going to have no choice but to address the relationship squarely in Georgia, Russia number 2, because it concerns conduct within South Ossetia, so an area where Russia might be regarded by the European Court of Human Rights as in occupation, because what their definition of occupation is unclear. It appears not to be the same as the Hague Law definition. So they've got that, but they've also got acts of the Russian forces in, if you like, Georgia proper, the heart of Georgia, like the airstrike on Gori. So there will be no option but actually consider the relationship. And I suspect that they may, knowing that, choose to address the issue in an earlier case. That's the Al-Skani case against the United Kingdom with regard to Iraq. So keep your eye on that case law. It's going to, I think, start changing. But part of the problem has been the way that cases have been pleaded, the inter-American system, partly because the Commission could determine itself how it articulated issues. It's done a much better job than the European Court of Human Rights.
Well, I'm afraid, ladies and gentlemen, that'll probably bring the end of it. There's been much talk of trains missing stations and leaving without people. I'm afraid that's the case for this particular panel, but I can assure you if it's run by British Rail, there'll be heaps of time to catch up. We've been very fortunate to have 3 scholars this morning who have immense depth of knowledge and experience, and I think that's been reflected by their comments and the engagement we've had over the question and answer period. And I'd ask if you would join with me, please, in thanking them this morning for their contribution.